Good afternoon. Welcome to today's webinar. Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. Welcome to today's webinar. Sorry, a little bit of a glitch, but here we are. Changes to the Family Law Act, property, pets and private information, what you need to know. This afternoon, I have Marianne Huth, the Director of our Family Law team, joining us. Thank you, Marianne.
Thank you.
And just before I hand it over to Marianne for the presentation, I'll just run through a little bit of housekeeping. My name is Kiara. I'm a Community Legal Education Officer here at Legal Aid. Today's webinar is being recorded. The laws and content is accurate on the day of the live presentation and may change. Information is on our Community Legal Education Resources page on the Legal Aid Queensland website. And for any technical support, you will need to contact the GoToWebinar customer support team. Unfortunately, we're unable to help you externally from here. Today's webinar will be approximately 40 minutes of presentation with 20-minute questions and answers at the end. Thank you to everyone who has preemptively submitted your questions. We have a lot of interest in today's webinar. Marianne has graciously offered to take some questions as we go through, but I will triage them so that we do get to hear the whole presentation. And if there are any questions that we may not get to, I can send them over and hopefully someone from our family law team will be able to get back to you. You are able to access a copy of the handouts just in the download handouts section at the bottom of the screen. But I will also be sending through a copy of the presentation once the recording is ready for you to access. So just a quick poll today, just to gauge where everyone is joining us from. So it's which region do you work in? South East Queensland, Far North Queensland, Regional Queensland or outside of Queensland? I'm just going to launch that quickly. And I'll give everyone a few more seconds. And I'll just close that out. Okay, so we have 61% joining us from South East Queensland, 14% from Far North Queensland, 17% from regional and 8% of outside of Queensland. So today's content, is that primarily for Queensland or Commonwealth legislation?
It's Commonwealth legislation.
Wonderful. So just going to get rid of that poll. And I'll hand it over to Marianne. Thank you.
Thanks, Kiara. So I'll just outline a little bit about what I am going to be covering today. It's going to be about what's changed in family law, and that's about how the court decides property disputes, including the process and the steps that the new legislation takes. And I'll discuss what the court can and can't take into account. There's some changes to disclosure requirements and how the court will manage property cases. As well as discussing companion animals, which are pets in property cases. And there's new parts of the Family Law Act about protecting sensitive information in family law cases. And I'll also talk about how the court deals with cost orders and a few more things along the way. So there's been some changes to the Family Law Act last year in 2024. There was some legislative change made to the parenting parts of the Act. And then there's this set of new changes to the Family Law Act in 2025 about clarifying the approach to property division and encouraging parties to resolve their matters outside of court or as soon as they can in the court process. These changes, these two sets of changes, came out of an Australian Law Reform Commission report in 2019, which recommended changes to the Family Law Act to simplify both the parenting and the property parts of the Act, and also to put in place some improvements so that orders of the court were complied with, and to add some clearer consequences in the court process to help matters to resolve quickly, inexpensively and efficiently with the least acrimony between the parties in the court. So I'm just going to outline an overview of what's changed in the legislation for the 2025 amendments. There's been an expanded definition of family violence. There's the legislation now includes the four-step process, which the court needs to take when deciding property division matters. The court's beefed up and added to family violence being considered as a factor in property matters. The legislation allows decisions to be made about ownership of companion animals, which is the pets, and there's been some changes to the way divorces work in the family court. And as well as those things, the court has implemented some less adversarial approaches to litigation. And the legislation also includes the ability for the court to get more information from the Commonwealth about parties and safety. There's been some changes in relation to the Section 60I certificate, which is the certificate that parties need to produce when they want to start litigation in the family court. And it enables the court to refuse to start a case without a Section 60I certificate. And there's also been some changes to the costs orders that the court can make during the course of litigation, particularly around paying the costs of the independent children's lawyer. And the legislation also introduces an accreditation program for children's contact centres. So, starting out with the definition of family violence, it's a new definition which retains the old references to physical violence and coercive control, but the new definition, section 4, capital A, capital B, includes descriptions of economic abuse, such as controlling access to money and assets. It includes withholding financial support as a means of economic and financial abuse. And it also includes where the person who is dependent upon the other party for financial support and that support is withheld. So the financial abuse definition has expanded to cover a whole lot of things that weren't originally in the legislation, so that if a person is hiding money or hiding spending of their money, the court can take this into account. And it also includes dowry abuse. So it expands the court's understanding and application of the economic effect of family violence, which needs to be considered when making decisions about the property held by the parties after separation. So that's a really important change to the legislation. Previously, the courts, when making decisions about property matters, there was a run of decisions made by the court which evolved a four-step process to divide for the considerations about how to divide the parties' property following separation. So that's now been included and is part of the Family Law Act. And as you can see on the slide there, the 4 steps are to identify the property and the assets of the parties and any debts or liabilities that the parties have. The second step is then to assess each party's contributions to the property pool, and that includes contributions which may not be financial, but are about care and welfare for the family. The third step is then to consider the current and the future circumstances of the parties and make an adjustment to what the split might be if it is just and equitable to do so. And then the fourth step is to determine the overall split of the percentage of the property and then proceed to make orders to allocate property, assets, debts and liabilities to implement the decision that the court has made about how the property should be divided. It includes changes which recognise coercive control and financial abuse in that scenario. The other thing that's changed in the property space is when the court is considering current and future needs of the parties, there's a couple of extra considerations added into section 79(4) of the Family Law Act. That is about including considerations about the effect of family violence on the ability of a party to make financial and non-financial contributions. So section 79(4) of the Act sets out a bit of a list of the contributions the court needs to consider when assessing property settlement. The extra ones around family violence allow the court to consider the impact on a party's ability to work, get wages and the like. And it also takes into effect any wastage of the property that a party might have done during the course of the relationship. And that wastage can be using money in a way that doesn't contribute to the family. A good example of that might be gambling, or using money to buy things that aren't things that would be helpful to the family's financial circumstances. And it can also include recklessly using money or incurring liabilities, getting debts or racking up debts which have an impact on the financial future of the parties. So that's a new set of considerations and new additions to the financial decision making in the family court. The other thing that's changed as well is that the court, the Act now has an explicit consideration when considering the current and future needs of the family about providing the need to provide housing for a child under the age of 18. So that's a new thing that's also been added in. And while we're talking about these things, it's important to remember that the Family Law Act and section 79(4) deals with parties who have been legally married, but the Act also does change. As I say at the bottom of the slide, the provisions also changed for parties who come to the court and want to seek orders in relation to division of their property, and they've been part of a de facto relationship. So all of the stuff around this applies to both marriages and de facto relationships. There's always been a duty of disclosure in the Family Law Act for parties to provide all of the information about their financial circumstances, but it's been beefed up in this new change to the legislation. Previously, the duty of disclosure sat in the Family Court rules, and it's now been moved into the Family Law Act, so it's got a bit more heft. So the obligations for parties to disclose in property matters are that parties must give to the other party all of the relevant information, financial information and documents to each other and to the court. And that obligation or duty of disclosure arises not just when the litigation starts, but when litigation is actually being contemplated for financial matters, and the obligation is ongoing until the matter is either resolved or finalised by the court. So it's a much more expanded responsibility in terms of time, and it's important that as soon as parties start to consider whether or not they are going to need to do some sort of property settlement, they have this ongoing obligation to provide disclosure about all of their financial circumstances for the time all the way through to the end of the litigation. So legal practitioners also have an obligation to advise their clients about this duty and to encourage them to comply with their duties of disclosure. There are penalties for not complying with this responsibility, and legal practitioners need to advise their clients about the consequences if they don't comply, which can include a finding of the court of contempt. And there are some consequences which include up to and including imprisonment if they don't comply. But more generally, and in our experience, if people don't comply with their obligations for disclosure, they could be facing a costs order, or the court might take into account their non-disclosure and non-compliance with their obligations when they determine the property settlement decision. And we're on to companion animals. This is the pets part of the webinar. So pets have always been something that has turned up in property settlement. Well, not always, but sometimes turned up in the property settlement part of decision making. Previously, they weren't seen as a separate thing in the property. They were just seen as a piece of property. So they were turning up in the balance sheet of property settlement matters previously, and they were allocated a notional amount of value or a price. This change to the legislation is a subtle change, but an important one, I think. A companion animal can be any type of animal, but there are some requirements about what is a companion animal. It's an animal kept by the parties, primarily for companionship. It can't be an assistance animal, so that's most likely a guide dog or another animal under the Disability Act. So a companion animal is not a guide dog or an assistance animal, and a companion animal isn't an animal that is used by a business or for an agricultural purpose. So it needs to be basically a pet. So the court's got some capacity to make some decisions about the ownership of a companion animal. That the court can make an order that one party to the relationship or somebody who is joined to the proceedings, and conceivably that could be another interested party in the property settlement proceedings. So a party to the relationship or someone joined in the proceedings can be given an order that they have ownership of the animal, or it can be transferred to somebody else outside of the dispute, or it can be sold. The court cannot make any other orders than those types of orders. So the court's not going to be making any shared care orders about dogs. They're not going to be, doing a week about arrangement for a dog. It's just about making an order about ownership for the dogs. or a pet. So these changes, at least in my assessment of them, allow some nuance about ownership of the pets and which party should have ownership of the pet after the relationship concludes. So the definition of a companion animal and the limits of what the court can do, it is set out in the slide, but it's basically got to be an animal that is defined as a pet. So in making a decision about the ownership of a pet, the court needs to, under the changes to the Family Law Act, consider the circumstances of when the pet was acquired and how it was acquired and by whom. The court will likely look at who registered the pet and was the owner and possessor of the pet. The court can consider who cared for and paid for the maintenance of the pet. The court will also consider any family violence between the parties and history of cruelty or threatened cruelty to the pet, take into account any attachments that the children of the relationship might have to the pet, and look at the ability for the parties in the relationship to be able to care for the pet and any other circumstances which are required for justice to be considered. Okay, the next change to the Family Law Act out of the most recent amendments is for the court, when they are deciding child-related proceedings, to take a less adversarial approach to the litigation. A less adversarial approach basically means that the court doesn't run the proceedings in a really strictly formal black letter type of way. It allows some flexibility in the way that the court approaches the process of the litigation. And that can mean that the court will maybe not run completely formal hearings and the like. And it also could mean that the court will make maybe an interim decision where required, or make some other procedural changes to allow the case to proceed in a much less formal way. So the court's got some powers to actively manage the litigation and to reduce stress and any intimidation during the court process. In a practical way, this might include allowing parties to attend by remote means, or taking steps to ensure that if a person has to give evidence, say at a final hearing, it could happen by technological means instead of in the courtroom. This allows, the clients to be supported, but the changes in the legislation also allows decision makers to conduct, so judges and other decision makers, SJRs and the like, to conduct the proceedings in a way that might be less formal than strict court proceedings. And so, that might mean that the court can make final consent orders on issues that are agreed at a fairly early stage, so that that issue is disposed of at an early stage. Having a limited hearing on a very small piece of the dispute, so that that's disposed of. And allowing evidence to be admitted that might not comply strictly with the evidence rules which are generally in place. And so that will mean that potentially the court can conduct the proceedings without delay and with as little formality and technicality as required. And these changes to enable the less adversarial approach applies across most of the decision making that court will make in child-related matters. It applies to proceedings that happen in chambers, so that's actually not physically in a court like a judicial registrar or a senior judicial registrar making a decision up to a final hearing. And these approaches can be done if the court chooses or makes a decision that that's how the particular case should run. When doing a case using this less adversarial approach, the court must ask about risks of family violence in the matter. The court must determine the issues which require investigation and can be disposed of summarily, so that's without a full and complete hearing. The court can determine the order of the issues that need to be decided and may make decisions about a particular issue in a particular order which suits the way that the litigation should be run more efficiently. The court can use technology, as I've talked about, encourage the parties to consider family dispute resolution and counselling where appropriate during the course of the litigation, and the court can try to deal with as many matters as it can on a single occasion before the court. And the legislation there, section 102NJ, says that the court can make determinations, findings and orders at any stage of the proceedings. So that's designed, I think, to ensure that the litigation is hopefully run in a way that suits the issues that are in play, and also to try and reduce the stress on the parties and to ensure the court's resources are utilised appropriately. When a matter is in the less adversarial approach, that section of the Family Law Act 102NL allows the rules of evidence not to apply. So that's allowing evidence in that may not necessarily have been allowed in if the strict rules were applied, but it also allows the court to manage the proceedings so as to reduce stress and facilitate safety for the parties. There's been some small changes to arbitration in the new parts of the Family Law Act. Arbitration is a process where parties can, instead of having a matter go to a judge to make a decision, they can agree to arbitration, and that dispute then is determined by the arbitrator. And the court essentially doesn't make the decision. So the court can refer family law matters to arbitration if all of the parties agree. And section 13E of the Family Law Act sets out the list of matters which are able to be arbitrated. As I've mentioned, the court can make an order by consent for the matter to be arbitrated. If there's any technical issues or things that need to be worked out, the arbitrator can apply back to the court, seeking orders about the conduct of the arbitration, including terminating the process of arbitrating and return the matter back to court if there is a change in circumstances or if there are safety concerns about the parties' participation in the arbitration process. Arbitration can be a really efficient way for parties to resolve their dispute. They're essentially foregoing the long and sometimes difficult process of litigation, and arbitration is generally a quicker process by a decision maker that has experience in making those sorts of decisions. And there's a national panel of arbitrators who do that sort of work. So essentially the parties, this works for the usual property settlement type of matters, but it also includes issues around spousal maintenance. If there's an issue about a binding financial agreement, the legislation allows that to be arbitrated. Questions about super splitting and cases where one party has refused to sign a document after court orders. So that is also a matter that can be arbitrated. So that's an interesting new change to the arbitration process in the legislation. The next change is, the next part of the legislation that's changed is to commence the process of establishing accreditation rules for children's contact services. So those of you out in the audience that practice in family law, there's a lot of people who use children's contact centres because they're a good way for people to have some safety around children spending time with the other parent. There hasn't been a lot of regulation around contact centres, and this legislation, or this change to the legislation, starts the process of establishing an accreditation process. So that's currently out to the Attorney General's Department has recently started a process of consultation around accrediting contact services. The intention is that once the rules and a scheme have been developed for accreditation, then the court will only be able to refer families to accredited providers to the scheme. And there will be some offences created for centres who pop up that aren't compliant, and that the process of consultation will take some time. So I guess it's a watch this space. I think the Attorney General's website, the Commonwealth Attorney General's website, either has or will shortly have some information about the consultation process. And I imagine after the consultation process, there will be a report prepared, and then the accreditation process will be completed. So I guess watch this space for this at the moment. So the next change in this Act is that there's some changes to the requirements to be able to get a divorce. The Act changes the requirement which had parties having to have counselling if they were married less than 2 years before they could apply for a divorce. So that requirement's actually been removed. There's no requirement to have attended counselling if you're divorcing prior to having been married for 2 years. And previously, if parties were seeking a divorce and there were still children under the age of 18, there was a requirement that that either if it was a joint application, both parties attend for the hearing of the divorce, or if it was a single application, the person who brought the application attend personally for the divorce or attend online for the divorce application. That's also been removed. So this change to the legislation will mean that divorces can happen without the attendance of the parties, and they'll be likely to be a routine administrative process that just happens in the back end of the court, and the parties will be notified once their divorce has been approved. Okay, so the next change is about Section 60I certificates. A Section 60I certificate is the certificate that has been required to be provided when starting a case in the family court. So it is a certificate that says either the parties have attended a mediation or a genuine attempt at a mediation has occurred. So somebody has tried to start a mediation, the other party has refused to attend, and they're provided by family dispute resolution practitioners who assist the parties with a family dispute resolution process. So if the parties have attempted, or one party has attempted to set up a family dispute resolution process and the other party has refused, you will get a 60I certificate. So this legislation tightens up the requirements for a Section 60I certificate to be provided when starting a case in court. There still remains the current exemptions for not needing a 60I certificate to start a matter if there are issues of significant urgency or if there are issues of abuse or violence, which meant that attempting a mediation pre-filing wasn't appropriate, or if one of the parties was not able to or had some incapacity which prevented them from participating in FDR, that's still an exemption. And there's an additional exemption added in this part of the legislation which says that if there was an order and there is a party who is in contravention of that order, and there is that contravention is so serious in disregarding the order, that will also mean that there doesn't need to be a 60I certificate to start proceedings about that. So this section tightens up this requirement such that the court now can refuse to start or refuse to allow filing of a parenting application if there is no certificate and none of the exemptions apply. There will be a limited review process of that decision by the court, but it just means that the parties do have an increased obligation to attempt mediation before filing and to get a Section 60I certificate, unless, of course, the exemptions apply.
We had a quick question, Marianne. Someone has just asked, for arbitration, do you insert an order to have the matter sent to arbitration? Or essentially, what is the process to request this of the court? Is there anywhere that they can access that kind of outlines that process?
Yes, I think there will probably be some information on the court's website about matters being sent to arbitration through the court. I haven't actually looked, I apologise, but I expect it'll either be in the rules of court or yeah, it'll most likely be in the rules of court.
Well, thank you.
So the next thing that changes in the Family Law Act is about protected confidences. So protected confidences is an addition to the Act, which is, I think, designed to ensure sensitive information that about the parties to the proceedings being used as evidence in family law matters. The legislation has changed, and I think the ideals of the changes to the legislation are to ensure that people can feel safe to be getting support from health, family violence and sexual assault services, and that the information that those services obtain, retain after assisting that client, and then be prevented from becoming evidence in the family law matter if that's appropriate. So these provisions stop that sensitive information being seen or used as evidence and protect their sensitive information from being made evidence in the family court proceedings. The legislation allows the court to consider and make some decisions about sharing that sensitive information and whether or not sharing it would cause harm to that party and whether or not it should be kept private. So just outlining what might be a protected confidence under this legislation. The legislation says a communication that is made to a confidant, so that can be a broad range of helping professionals, counsellors, sexual assault services, family violence services, a health professional, and there's a reasonably wide definition of a health professional. So that's, of course, a doctor, a psychologist and those sorts of professions helping clients. If that professional is required to keep the information confidential because of their own professional obligations, psychologists, doctors, they have obligations of confidentiality. So if it's a requirement for that professional to keep that information confidential, then that communication is by definition a protected confidence. It's also considered that we also need to consider that the sensitive information relates to the help or the treatment received by the person. So protected confidences are likely to be medical records, counselling notes, even as far as prescriptions, specialist health services like DV and sexual health services. But it also can include broader things like discussions between health professionals, so not necessarily with the client themselves, but discussions between health professionals about a person. And it can include information provided about a person by others. So if a support person talks to a health professional, a doctor, or another service about a particular person, the protected confidence as part of the Family Law Act kicks in for that communication. So it's actually quite a broad range of information that is protected by this part of the legislation. So if those sorts of notes or disclosures or discussions or information is being sought, who can ask to protect that information from being disclosed as part of the litigation? This is the list of people who might be able to say this information should be protected and not disclosed. So of course, the person who the information relates to, the person who sought the assistance of the helping professions, doctors and counsellors and the like, but also the makers of the records, so doctors, treaters, sexual assault services, those sorts of people can also ask for the information to be protected. If a person has a litigation guardian in the court proceedings, that litigation guardian can also ask for the information to be protected because they take the place of the person themselves as litigation guardian. If the information is about a child, a parent can ask for the information to be protected, or if there is already litigation on foot and there's an independent children's lawyer appointed to represent the best interests of the child, then that independent children's lawyer can also ask for information about that child to be protected in the court proceedings. And of course, the court retains the overarching ability to make a decision to protect information, particularly if there's issues around safety that are that might arise from the production of that information. So, if there are protected confidences or information which is a protected confidence, then when can information be protected? Essentially, any time after the case starts in the family court. There are a couple of events which might arise when to activate protected confidences being put into place, particularly when somebody issues a subpoena for things that might fall within the definition of protected confidences. During the course of litigation, as I've mentioned previously, there is a requirement on parties to provide full and frank disclosure. So when disclosure is requested or required during the course of a case, that is when information might need to be considered and protected. When documents are to be viewed, so if somebody's issued a subpoena and those documents have been provided to the court, then that might be a time when somebody might need to consider whether or not documents should be protected because they fall into the definition of a protected confidence, and when documents might be used for evidence or provided as to a report writer for part of the litigation in the case. So, using this part of the legislation, how can the court protect documents? Or how can the parties, if they're concerned, seek to protect the documents? Essentially, the parties can seek orders when the case starts. If they know that there is counselling notes or psychological notes or other medical notes which fall into the definition of protected confidences and they're starting proceedings, they can include in their application an order which seeks that certain types of documents be protected, or a decision to be made about whether or not they can be protected. If it arises partway through the course of the litigation, then of course parties can always make an application in a case for a decision about those documents being protected. If during the course of a case one of the parties brings an application and wants to issue a subpoena to obtain documents, and that subpoena is likely to request documents which should be protected under this section of the legislation, then the party who's impacted by that or the ICL, as I discussed previously, can file an objection and a decision could be made to allow the person who is impacted to inspect whatever documents are provided, so that they can then determine whether or not they continue with their objection to releasing the protected information in the case. So how will the court make decisions about protected information? The court has the ultimate decision-making responsibility to decide whether or not the protected information can be used in the case. When making these decisions, the court will consider whether there will be harm if the records are used, and whether sharing the information in the court proceedings is more harmful than having the benefit of the information in the case. So that's going to be a weighing up decision by the judicial officers around protecting the person whose records it is versus what that evidence might be used for, or how useful that evidence might be in the course of the case. So that's going to be an interesting thing to observe over the next little while, because this is likely to be something that judges and senior judicial registrars are going to be grappling with during the course of a parenting matter. So it'll be interesting to see what the court's response is and what sort of decisions come out of this new piece of the Family Law Act. It's worth noting that the parties can agree, if they choose to allow what would be protected information to be produced and used in a case. I'm sure there will be times when parties do have these notes and agree to them being used because they might be a powerful piece of evidence for their case. So it's not a blanket requirement that they not be used. There is some nuance in the decision making for the parties and of course for the court about the use of this material. It's also interesting in the legislation that even before a case starts, the information can remain can remain protected if it meets the criteria in the legislation, despite the fact that, you know, this case hasn't already started. So there's no obligation for that to be changed. So there's been some changes to the costs part of the Family Law Act. The general provision that the parties pay their own costs actually doesn't change with the changes to the sections of the Act about costs. But there have been some small changes. The court can make an order for security for costs or a costs order that justify it. So security for costs is where a party has to put up some money in a case where it might not have good prospects of succeeding and the like. So there's some changes around that. That I think is probably designed to ensure that if somebody might be starting litigation that might not have good prospects and they're doing it for a reason that might be to intimidate the other party or for family violence reasons, that allows the court to put up an order for security for costs and ask them to make, put their money where their mouth is. The other things that have changed is that there's different considerations or additional considerations when the court is asked to make an order for costs during the course of family law proceedings. And the court will need to consider the financial circumstances of the parties, whether they are in receipt of legal aid assistance that is means tested. So means tested means that, there's an assessment of a party's financial circumstances by the Legal Aid Commission. The court will also consider the conduct of the parties, whether or not there's been any failure to comply with any of the court orders, and whether or not there's been offers made to settle the proceedings, which could have avoided the proceedings going on and extra costs being incurred by the parties because of that, because the offers to settle weren't taken by the parties. The changes to the cost part of the legislation include that application for costs can be made during the course of the proceedings, and that's always been the case, but it also extends now to within 28 days of the proceedings concluding. So if a matter finishes, there's still a small window of opportunity for parties to bring an application for costs. There's also just a few changes in relation to the costs of an independent children's lawyer. If an independent children's lawyer has been appointed, the court can make a costs order that each party pays costs of the ICL in such proportion as been determined by the court. But of course, there's always an exception for parties who are in receipt of legal aid or there is demonstrated hardship for that type of order to pay the costs of the ICL. The legislation also outlines that if a person is in receipt of Section 102A funding, cost orders can be made for that party to pay or contribute to the ICL's costs, because 102A funding is not a means tested funding. The changes to the cost part of the Family Law Act also note that a person, usually an officer from a child protection agency who intervenes under Section 91B into the legislation, and litigation guardians who are acting on behalf of a party who don't have capacity, there are some protections in the legislation for cost orders if either of those two types of people are acting on behalf of the party or intervening in good faith. So that's a specific little piece which gives them protection for cost orders. And that's the end of my presentation. I've just added on the webinar some really useful links. The Attorney General's Department has put out a bunch of information sheets which are really good, quite detailed, worth reading about these changes, particularly about the one about protecting sensitive information is really helpful. And there's a couple of webinars that the Family Law Pathways group have done with the help of the Attorney General's Department, and I commend those to you because they're quite detailed and really helpful as well.
Wonderful. I'll ensure when we send out the slides after this that everyone's able, I'll put an extra copy of access to these in the email body so everyone's able to get into those sites. And just a general how legal aid can help you. So we do have our information legal advice line. Of course, we have Judy Lawyer.
Yes.
For so they'll be there if you are going to family court.
Yes, there's Judy Law is available. We've got the family law teams in each of the regional offices and in Brisbane have Judy lawyers available for the sittings in each of the regional courts and each day in Brisbane. They can be accessed either in person if you're in person at court, or there's access to phone advice and phone help if your matter is being dealt with remotely. Jump on the website, you'll find the resources to be able to access our Judy Lawyer service from there.
Wonderful. And just for the referral bit as well, so is that referrals through to legal aid or?
Well, legal aid generally gives help to parties in family law matters, as I said, Judy lawyers and those sorts of things. But we also accept referrals in from other places, but if they can't access help through legal aid, they can certainly see if they can also access help from community legal centres. And if parties want to have a private lawyer represent them, then they can certainly get onto the QLS website to see if they can access a referral through the Queensland Law Society.
Wonderful, thank you. So we're at the questions part of the presentation. Thank you so much, Ruth. This has been incredible. So we have reached our time, but if Marianne's okay to, if you want to send a question through, you can do it now. Otherwise, if you can send it through to webinars@legalaid.qld.gov.au, sorry, I'll send that to Marianne and someone in the family law team will be able to respond. So we have the changes now include a 4-step process for property settlement. What was the process previously and how have these changes improved the current?
The 4-step process has just been legislated into the Family Law Act. That's the big change. Previously, it was case law that had been developed over a significant period of time, that was the way that courts should decide the division of the property. And now it's just become a part of the Family Law Act. I think that probably helps make it clear and obvious, and that judges now have legislation to be guided by when they make those decisions as opposed to case law. So it'll be interesting to see how that pans out, but I think that's the significance of the change. It's just moved into the Family Law Act rather than being something that the judges knew about and used case law for.
Great. Were there any other questions? I understand the court cannot make orders for shared care arrangements for companion animals. I'm just so happy that there's at least something for animals now. But can that be done in consent orders?
The legislation is fairly clear that that's not possible. It's an ownership decision, and the court can only make shared care arrangements for children, unfortunately not for pets. So there will just need to be an ownership decision made about pets. That's what the legislation is designed to do.
Thank you. What we might do is if you can send your questions through to the webinar's email, then that way we'll ensure that someone's able to respond from the family team. Just a little bit of a wrap up here. So you can contact us on 1300 65 1188. That's just to get general legal information and advice. We have a priority line for Aboriginal and Torres Strait Islanders. That number is 1300 65 0143. And if you already have a grant submitted, a grant application submitted, and you have questions or a follow-up, please call 1300 383 900. All of our publications are available for free on the Legal Aid Queensland website, so you can access and order anything there. We're still finalising the topic for our next webinar, so if you sign up for our mailing list, we'll send that information out when that's done. As I mentioned before, in a few days we'll finalise the recording, and I'll send through a copy of the slides and then access to all those wonderful links for you to view. And of course, give us a follow on Facebook, LinkedIn, Instagram and X for all upcoming topics, dates and other useful legal information. Thank you, Marianne. This was incredible.
Thank you.
Thank you to our Auslan interpreters, and thank you to our audience for joining us. Hope you have a great afternoon.